In this video club we will see advancement of education and knowledge. When you see the UK Charities Act, it provides advancement of education, not the knowledge, because education includes knowledge. The education is balanced, systematic process of instruction or training or practice containing spiritual, moral and physical elements. That's known as education. Anything harmful to the society, that can't be a charitable trust. Sometimes there were cases, decided cases, some university union, they tried to challenge the government policy. Then in that case, court said that this is not education. This can't be education. Then come to the research part. When you say research, that should be for the useful object of the study or the subject. Then it is for the good thing, useful to the society. Second thing, that's a condition. Second thing is the results of the research should be available to the public. Then finally, it is for the benefit of public. Then these are the matters, these are the conditions are there to fulfill to be a charitable trust for the advancement of education and knowledge. The research in scientific subjects are generally for the benefit of public. Now we will see the other matter, advancement of religion and religious maintenance of religious rites and practices. Advancement of religion and maintenance of religious practices and rites and practices. In the UK Charities Act, that is for only advancement of religion. But in Sri Lanka, in the Trust Ordinance, section 99 of the Trust Ordinance provides that advancement of religion and maintenance of religious rites and practices, because in Buddhism and Hinduism and Islam there are heavily ritualistic practices. Now say there are so many rites and practices in those religions, but not in the Christianity. That's why generally when you in Sri Lanka, in the cases in Sri Lanka court, you can't cite the English authority as to decide the matters, because that's different from Sri Lanka laws. Anyway, only one case, in one case, Fernanda vs. Subramaniam, the Gilmore versus court case cited, but the court said that no, you can't submit or you can cite that case because that's a different criteria or different system. The Gilmore case, the performance of private ceremonies not for the public benefit. Suppose there is a ceremony or the festival in the temple, it may be charitable trust, may be private trust. In the Fernanda vs. Subramaniam case, in the case of Fernanda vs. Subramaniam, in the trust deed, it was like this: desires of my soul's attainment of salvation. And further stated, for the performance of religious ceremony. For the performance of religious ceremony. When you put together, we must see the central act of Hinduism. Then we must define. If you do some festival in the general public temple, it is beneficial to the general public. Then the court said that it is a private matter, but still it occurs in the public temple, then it is a charitable trust. It is a performance for the public benefit. The people, general people also participate in that religious functions. In that case, they also are getting some sort of benefit. That's why the court said that this is for public benefit. The benefit for general body of worshippers or the members of family, that's we must see. Whether it is for the general public who are in the temple or it is for members of the family. How to differentiate? Now suppose like this way. There's a festival in the general public mass or public times. Say suppose there's a puja in the scheduled time. In one of that time, the private individual, they are doing some puja, then all the general public also benefiting by that puja. But it is a private matter. It is not in the scheduled function. It is a separate special time allocated for members of the family. Then that is a private trust. Then another matter is here, whether it occurs in the public temple or the private temple. What is public temple? Anybody can go and pray there. That's a public temple. The private temple is, sometimes it is for the family members, it is for the group of people, that's a limited relatives or sometimes private people, that is private temple. Then in a public temple, public has some beneficial interest. What is the characters of these public temple? Main characteristics of the public temple is for the use of general public. There are so many factors to decide the temple whether it is a private or public. We can say so many things, but we will see some more things. Origin of the temple, how it is originated. Then the manner in which its affairs are managed, and nature and the extent of the gift received by the temple. How to manage the expenses of the temple. Then finally, concerns of the manager as well as devotees. How they feel this one. It is a public temple or private temple. That also one of them. Then these are the matters we must take into account and decide whether it occurs in a public temple. That's a charitable trust. If it occurs in a private temple, that's a private trust. No, there is nothing known as private charitable trust. Either it should be charitable trust or private trust. Then only we can identify whether it is for charitable or not. We have seen relief of poverty, that is an exception to the general rule that we have seen. Advancement education that we have seen. And finally we have seen advancement of religion and maintenance of religious rites and practices. Now finally that we have seen anything beneficial to the mankind. That is something vague area, that's something open area. We must bring anything and everything under this one. The beneficial to the public in the sense, it is something, sometimes if it is beneficial to the animal, that can't be a charitable trust. Say suppose there's a trust to protect the stray dogs, that can't be a charitable trust. But that should be for the benefit of general public. But still, even a gift for the benefit and protection of animals helps to promote the feelings of humanity and encourage or discourage the cruelty towards animal and encourage the kindness towards animal. This is something modifies the human activities. In that case, it is for the benefit of public. Even though it is created for animals, finally it is for the benefit of human beings or mankind. In that case, it is for the public benefit. Then it may be a charitable trust. But in Sri Lanka, there was no cases. But in English, there are so many cases in English law. But after 2011, the Charities Act amended, and the charities includes even promotion of welfare of the animals. That is a separate clause given, but still that should be done for the benefit of public. That requirement even in UK applicable. It should be for the benefit of public. Finally, we will see the doctrine of cy-près. The doctrine of cy-près in Sri Lanka known as adaptation. Section 99, subsection 2 provides that the expression adaptation with reference to a trust means adaptation of trust in such a manner as to carry out the wishes of the author of the trust as nearly as practicable according to the doctrine of cy-près, which is not possible to carry out those wishes in an exact manner prescribed by the instrument of trust. The trust, deed of trust, clearly define the wishes of the author of the trust. Generally what we have seen, you can't deviate from that one. Generally we decided. Generally that's a law. But if it's a private trust, you can't deviate from what is in the deed of trust. But here, if it's a charitable trust, you can deviate little bit. You can deviate from that wishes. If it is not practicable, but it is good for the benefit of public, then just you can deviate and give effect to the trust. That is known as doctrine of cy-près or adaptation in Sri Lanka. That is the end of charitable trust. Thank you very much for watching this.